On the contrary, an unbroken tradition of prohibiting abortion on pain of criminal punishment persisted from the earliest days of the common law until 1973. The court in Roe could have said of abortion exactly what Glucksberg said of assisted suicide: attitudes toward abortion have changed since Bracton. But our laws have consistently condemned and continue to prohibit that practice. Respondents and their amici have no persuasive answer to this historical evidence. Neither respondents nor the Solicitor General disputes the fact that by 1868 the vast majority of states criminalized abortion at all stages of pregnancy. Instead, respondents are forced to argue that it does not matter that some states prohibited abortion at the time Roe was decided or when the 14th Amendment was adopted. But that argument flies in the face of the standard we have applied in determining whether an asserted right that is nowhere mentioned in the Constitution is nevertheless protected by the 14th Amendment. Not only are respondents and their amici unable to show that a constitutional right to abortion was established when the 14th Amendment was adopted, but they have found no support for the existence of an abortion right that predates the latter part of the 20th century, no state constitutional provision, no statute, no judicial decision, no learned treatise. The earliest sources called to our attention are a few district court and state court decisions decided shortly before Roe and a small number of law review articles from the same time period. A few of respondents' amici muster historical arguments, but they are very weak. The Solicitor General repeats Roe's claim that it is doubtful abortion was ever firmly established as a common law crime even with respect to the destruction of a quick fetus. But as we have seen, great common law authorities like Bracton, Coke, Hale, and Blackstone all wrote that a post-quickening abortion was a crime and a serious one at that. Moreover, Hale and Blackstone, and many other authorities following them, asserted that even a pre-quickening abortion was unlawful and that, as a result, an abortionist was guilty of murder if the woman died from the attempt. Instead of following these authorities, Roe relied largely on two articles by a pro-abortion advocate who claimed that Coke had intentionally misstated the common law because of his strong anti-abortion views. These articles have been discredited, and it has come to light that even members of Jane Roe's legal team did not regard them as serious scholarship. An internal memorandum characterized this author's work as donning the guise of impartial scholarship while advancing the proper ideological goals. Continued reliance on such scholarship is unsupportable. The Solicitor General next suggests that history supports an abortion right because the common law's failure to criminalize abortion before quickening means that, at the founding and for decades thereafter, women generally could terminate a pregnancy, at least in its early stages. But the insistence on quickening was not universal and regardless. The fact that many states in the late 18th and early 19th century did not criminalize pre-quickening abortions does not mean that anyone thought the states lacked the authority to do so. When legislatures began to exercise that authority as the century wore on, no one, as far as we are aware, argued that the laws they enacted violated a fundamental right. That is not surprising since common law authorities had repeatedly condemned abortion and described it as an unlawful act without regard to whether it occurred before or after quickening. Another amicus brief relied upon by the respondents tries to dismiss the significance of the state criminal statutes that were in effect when the 14th Amendment was adopted by suggesting that they were enacted for illegitimate reasons. According to this account, which is based almost entirely on statements made by one prominent proponent, important motives for the laws were the fear that Catholic immigrants were having more babies than Protestants and that the availability of abortion was leading white Protestant women to shirk their maternal duties. Brief for Amici Curiae, American Historical Association and Organization of America. And historians 20. Resort to this argument is a testament to the lack of any real historical support for the right that Roe and Casey recognized. This court has long disfavored arguments based on alleged legislative motives. The court has recognized that inquiries into legislative motives are a hazardous matter, even when an argument about legislative motive is backed by statements made by legislators who voted for a law. We have been reluctant to attribute those motives to the legislative body as a whole. What motivates one legislator to make a speech about a statute is not necessarily what motivates scores of others to enact it. Here the argument about legislative motive is not even based on statements by legislators, but on statements made by a few supporters of the new 19th century abortion laws. Motive. Instead of seriously pressing the argument that the abortion right itself has deep roots, supporters of Roe and Casey contend that the abortion right is an integral part of a broader entrenched right. Roe termed this a right to privacy, and Casey described it as the freedom to make intimate and personal choices that are central to personal dignity and autonomy. Casey elaborated, at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. The court did not claim that this broadly framed right is absolute. And no such claim would be plausible. While individuals are certainly free to think and to say what they wish about existence, meaning, the universe, and the mystery of human life, they are not always free to act in accordance with those thoughts. License to act on the basis of such beliefs may correspond to one of the many understandings of liberty, but it is certainly not ordered liberty. Ordered liberty sets limits and defines the boundary between competing interests. Roe and Casey each struck a particular balance between the interests of a woman who wants an abortion and the interests of what they termed potential life. But the people of the various states may evaluate those interests differently. In some states, voters may believe that the abortion right should be even more extensive than the right that Roe and Casey recognized. Voters in other states may wish to impose tight restrictions based on their belief that abortion destroys an unborn human being. Our nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. Nor does the right to obtain an abortion have a sound basis in precedent. Casey relied on cases involving the right to marry a person of a different race, Loving v. Virginia, 1967, the right to marry while in prison, Turner v. Safety, 1987, the right to obtain contraceptives, Griswold v. Connecticut, 1965, Eisenstadt v. Baird, 1972, Carey v. Population Services International, 1977, the right to reside with relatives. Moore v. East Cleveland, 1977, the right to make decisions about the education of one's children, Pierce v. Society of Sisters, 1925, Meyer v. Nebraska, 1925, the right not to be sterilized without consent, Skinner v. Oklahoma ex rel. Williamson, 1942, and the right in certain circumstances not to undergo involuntary surgery, forced administration of drugs, or other substantially similar procedures, Winston v. Lee, 1985, Washington v. Harper, 1990. Rochin v. California, 1952. Respondents and the Solicitor General also rely on post-Casey decisions like Lawrence v. Texas, 2008, right to engage in private, consensual sexual acts. And Obergefell v. Hodges, 2015, right to marry a person of the same sex. These attempts to justify abortion through appeals to a broader right to autonomy and to define one's concept of existence prove too much. Those criteria, at a high level of generality, could license fundamental rights to illicit drug use, prostitution, and the like. See Compassion in Dying v. Washington, 1996. None of these rights has any claim to being deeply rooted in history. What sharply distinguishes the abortion right from the rights recognized in the cases on which Roe and Casey rely is something that both those decisions acknowledged: abortion destroys what those decisions call potential life, and what the law at issue in this case regards as the life of an unborn human being. None of the other decisions cited by Roe and Casey involved the critical moral question posed by abortion. They are therefore inapposite. They do not support the right to obtain an abortion, and by the same token, our conclusion that the Constitution does not confer such a right does not undermine them in any way. In drawing this critical distinction between the abortion right and other rights, it is not necessary to dispute Casey's claim, which we accept for the sake of argument, that the specific practices of states at the time of the adoption of the 14th Amendment do not mark the outer limits of the substantive sphere of liberty which the 14th Amendment protects. Abortion is nothing new. It has been addressed by lawmakers for centuries. And the fundamental moral question that it poses is ageless. Defenders of Roe and Casey do not claim that any new scientific learning calls for a different answer to the underlying moral question. But they do contend that changes in society require the recognition of a constitutional right to obtain an abortion. Without the availability of abortion, they maintain, people will be inhibited from exercising their freedom to choose the types of relationships they desire. And women will be unable to compete with men in the workplace and in other endeavors. Americans who believe that abortion should be restricted press countervailing arguments about modern developments. They note that attitudes about the pregnancy of unmarried women have changed drastically. RAL state laws ban discrimination on the basis of pregnancy, that leave for pregnancy and childbirth are now guaranteed by law in many cases. That the costs of medical care associated with pregnancy are covered by insurance or government assistance, that states have increasingly adopted safe haven laws, which generally allow women to drop off babies anonymously, and that a woman who puts her newborn up for adoption today has little reason to fear that the baby will not find a suitable home. They also claim that many people now have a new appreciation of fetal life, and that when prospective parents who want to have a child view a sonogram, they typically have no doubt that what they see is their daughter or son. Both sides make important policy arguments, but supporters of Roe and Casey must show that this court has the authority to weigh those arguments and decide how abortion may be regulated in the states. They have failed to make that showing, and we thus return the power to weigh those arguments to the people and their elected representatives. We next consider whether the doctrine of stare decisis counsels continued acceptance of Roe and Casey. Stare decisis plays an important role in our case law, and we have explained that it serves many valuable ends. It protects the interests of those who have taken action in reliance on a past decision. It reduces incentives for challenging settled precedents, saving parties and courts the expense of endless relitigation. It fosters even-handed decision-making by requiring that like cases be decided in a like manner. Payne v. Tennessee, 1991. It contributes to the actual and perceived integrity of the judicial process, and it restrains judicial hubris and reminds us to respect the judgment of those who grappled with important questions in the past. Precedent is a way of accumulating and passing down the learning of past generations, a font of established wisdom richer than what can be found in any single judge or panel of judges. N. Gorsuch, A Republic If You Can Keep It, 2019. We have long recognized, however, that stare decisis is not an inexorable command. Pearson v. Callahan, 2009, and it is at its weakest when we interpret the Constitution. Agostini v. Felton, 1997. It has been said that it is sometimes more important that an issue be settled than that it be settled right. But when it comes to the interpretation of the Constitution, the great charter of our liberties, which was meant to endure through a long lapse of ages. Martin v. Hunter's Lessee, 1816, we place a high value on having the matter settled right. In addition, when one of our constitutional decisions goes astray, the country is usually stuck with the bad decision unless we correct our own mistake. An erroneous constitutional decision can be fixed by amending the Constitution, but our Constitution is notoriously hard to amend. Therefore, in appropriate circumstances we must be willing to reconsider and if necessary overrule constitutional decisions. Some of our most important constitutional decisions have overruled prior precedents. We mention 3. In Brown v. Board of Education, the court repudiated the separate but equal doctrine, which had allowed states to maintain racially segregated schools and other facilities. In so doing, the court overruled the infamous decision in Plessy v. Ferguson, along with 6 other Supreme Court precedents that had applied the separate but equal rule. The court overruled Adkins v. Children's Hospital of D.C., 1923, which had held that a law setting minimum wages for women violated the liberty protected by the Fifth Amendment's Due Process Clause. West Coast Hotel signaled the demise of an entire line of important precedents that had protected an individual liberty right against state and federal health and welfare legislation. Finally, in West Virginia B.D. of Ed v. Barnett, 1943, after the lapse of only 3 years, the court overruled Minersville School Dist v. Gobillis, 1940, and held that public school students could not be compelled to salute the flag in violation of their sincere beliefs. Barnett stands out because nothing had changed during the intervening period other than the court's belated recognition that its earlier decision had been seriously wrong. On many other occasions, this court has overruled important constitutional decisions. Without these decisions, American constitutional law as we know it would be unrecognizable, and this would be a different country. No justice of this court has ever argued that the court should never overrule a constitutional decision. But overruling a precedent is a serious matter. It is not a step that should be taken lightly. Our cases have attempted to provide a framework for deciding when a precedent should be overruled, and they have identified factors that should be considered in making such a decision. In this case, 5 factors weigh strongly in favor of overruling Roe and Casey.